The Honorables, presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Welcome to the North Carolina Court of Appeals. I'm your presiding judge today, Hunter Murphy. Joining me is Judge Toby Hanson and Judge Reuben Young. We are on this afternoon for Court of Appeals file number 19-1107, Thomas McDonald, plaintiff appellant versus Dr. Sari H. Saini and Carolina Plastic Surgery of Fayetteville, defendants appellant. The appellant has asked to reserve 10 minutes, and we will mark that rebuttal time. And also today we wanted to thank our IT director, Fred Wood, and the entire IT department for the Supreme Court and North Carolina Court of Appeals for all their hard work over the last few months to make sure that we can keep doing these oral arguments in a timely fashion. I want to thank our clerk of court, Dan Horn, for being here. Unfortunately, his face only appears as the timer, so we won't get to see him during this oral argument, but Dan is there listening to everything we're doing and probably not happy with me right now. But I just want to identify counsel, if I would. I understand counsel for plaintiff appellant here today is Michael Porter and Reed Noble. Is that correct?
That is correct. That's correct, Your Honor, and we're here with our client, plaintiff appellant Thomas McDonald.
Thank you. And the counsel for defendant's appellee, I understand it's Ms. Gloria Becker is here doing the oral argument. Also of record are Ariane Blondina and David Batten, all of the Batten Lee law firm. Ms. Becker, is anybody else going to be joining you? Thank you very much. With that said, and seeing that everybody's able to hear and be heard, I will allow the appellant to begin your oral argument.
May it please the court. The plaintiff appellant is respectfully requesting that this panel reverse the trial court's order granting defendant appellee's motion for summary judgment, and that this case be remanded to Cumberland County Superior Court for further proceedings. Allow me to give a brief statement of the case. The plaintiff appellant, Thomas McDonald, had surgery performed by the defendant appellee, Dr. Sarah Saini, on or about October 31st, 2014. This was a routine liposuction. Mr. McDonald initiated this medical malpractice action by filing a complaint on February 27th, 2018. The defendant filed a motion for summary judgment, and thereafter the Honorable Gail Adams, Cumberland County Superior Court judge presiding, heard arguments on the motion and granted an order dismissing the case and granting the defendant appellant's motion for summary judgment on or about May 13th, 2019. The plaintiff appellant timely filed an appeal, timely filed a record on appeal, timely filed briefs, and we are now before your honors for oral argument. This is a very simple case. The sole issue to be determined today is an evidentiary issue, and that issue is whether expert witnesses in North Carolina can use the differential diagnosis method or differential diagnosis etiology in forming their opinions in order to satisfy Rule 702A2. That's it. And if you recall, the recently revised Rule 702, 702A specifically, says that 3 prongs must be satisfied in order for an expert to provide opinion testimony. Number 1, the testimony is based upon sufficient facts and data. Well, in this case, those facts and data are the medical records and the resulting injuries. I don't believe that there is any disagreement that that prong has been satisfied. Number 2, the testimony is the product of reliable principles and methods. I believe that's where the argument is. Number 3, the witness has applied the principles and methods reliably to the facts of the case. Well, we know that one's satisfied because Dr. Erdman gave lengthy deposition testimony where he discussed applying his methods to the medical records and the injuries that he observed.
So now, if I can, sorry, Mr. Porter, if I can jump in just just quickly. But that seems to be sort of the crux of the argument here, is that the contents of those opinions, and were those opinions grounded on anything more than speculation, conjecture, the sort of language we all know well in some complex medical causation cases. And so where in this record can you point to provide those kind of more concrete types of diagnoses or concrete types of opinions, in this case, to overcome that bar?
Yes, I'll be happy to address that issue, Your Honor. He testified at length, and this is, I believe, page 127 of his deposition through 130. And he went through where he saw the breaches of the standard of care. And then I think the key thing here is the reliance on the defendant appellant on the magic word of speculation. Now, there's case law that says if it's speculation, it's not allowed. But first of all, there was a language barrier. Dr. Erdmann is from Heidelberg, Germany. But second, if you actually look at the Black's Law, speculation is defined as the act or practice of theorizing about matters over which there is no certain knowledge. And that's exactly what we have here. Dr. Erdmann testified that he's using the word speculation, which is theorizing, because he wasn't literally in the room, and the medical records and Dr. Saini are silent as to what caused these burns. And for today's purposes, obviously, these are burns in the light most favorable to the plaintiff appellant. And so to get to the crux of it, Your Honor, he lists out the breaches of the standard of care. And then if you look in my brief, I don't want to go over what's already in the brief because I'm sure you've read it. He does work backwards from the injury, which is allowed. And he says this had to have been caused by the breach of the standard of care. And that is the differential diagnosis method. And the brief gets into that in detail. And it's the same standard or the same scientific method that is utilized in child abuse cases, for example. So I believe the ramifications on the ruling in this case, although we're in a medical malpractice case, I think it is easy to lose sight of the fact that the evidentiary ruling today will have ramifications for expert witness testimony throughout many types of cases. And I believe, respectfully, that if this court holds that Dr. Erdmann's testimony does not satisfy Rule 702A2, then I do not know how any doctor whose specialty is diagnosing child abuse, especially for nonverbal children, will ever be able to testify in court. If the defendant parents or caregivers were to go silent and the child is too young to speak or dead, well, it would be speculation. It would, if you're not in the room. And so, Your Honor, I hope that answers your question. I apologize if it was a little long, but he does work backwards from the fact of these are burns.
So part of the issue in this case, though, perhaps and somewhat different, perhaps in child abuse cases and most alleged medical negligence cases, is that we weren't in the room when it happened, right? And we don't have the records to show what happened in the room. Usually you're able to sort of recreate what happened based on the medical records, nursing notes, surgical records, et cetera, et cetera. And we seem to have that gap here, and testimony of your expert is, well, one of these three different things could have been the cause of it. And I noticed in your complaint, you did raise a res ipsa.
Yes.
And in some ways, this seems to be somewhat, and I'm playing devil's advocate a little bit here, but it can be said that this is an attempt to try and sort of backdoor in a res ipsa claim, where you just simply don't have the expert testimony to support, a standard negligence and causation claim. So how does your theory of res ipsa play out in this scenario? I mean, I'm trying to figure out how all the claims kind of fit together. Is this, it sort of screams a res ipsa argument.
And it's res ipsa is very similar. Obviously, when you're a plaintiff's counsel, you put in every claim that you have out of an abundance of caution that you could possibly raise. And I do think it is similar. However, this case is more similar to the Humphreys case that I cite in my brief. And in Humphreys, just as, and I believe here, we get over the hurdle, because if you look at Humphreys, it was a positioning case. And just like in that case, the expert could not definitively say the exact mechanism of injury. The plaintiff's expert said, well, it could have been a hyperextension. It could have been they laid him. And obviously, the plaintiff in that case was sedated. And so malpositioning caused extreme damage to one of his limbs. But what he did definitively state is that this injury in Humphreys was caused by a breach of the standard of care by positioning. And I don't know exactly how the plaintiff was mispositioned, but that's what occurred. In this case, you have Dr. Erdman saying these are full thickness, third degree burns outside of the surgical incisions wherein you should never have burns. And I don't know exactly how Dr. Saini caused these burns, but she did. And the only way she could have caused them was with a heat source. And we identified, or Dr. Erdman identified, two potential heat sources. One, which was the Boviforce Valley Lab cautery tool. And also, he theorized that despite what Dr. Saini is saying, that the blank in the medical record was a Vaser, V-A-S-E-R, liposuction device. Now, I know the defendant appellants hotly contest that, but as you know, that's what's considered a disputed issue of fact. So this case, it's easy to go down the rabbit hole of res ipsa because it seems to be like, well, there's an injury and they're just saying that there's an injury, therefore something happened. But in this case, just like in Humphreys, Dr. Erdman made that next step. He went all the way. And quite frankly, the fact that Dr. Saini, as the defendant appellant, cannot explain full thickness third degree burns goes to her credibility or lack thereof and buttresses Dr. Erdman's expert testimony. And moreover, just like in the Humphreys case, there was an issue of lack of appropriate documentation in the medical records. And that's exactly what we have here. Dr. Erdman, who is the chief of plastic surgery at Duke University, testified repeatedly that there is simply nothing in the medical records that explains full thickness third degree burns. And with the court's permission, I would like to show a few documents, but I'll pause if anyone else has any questions before I continue.
I'm fine if you want to go ahead.
All right. Hopefully my training kicks in. The first document that I'm showing you is what the plaintiff appellant Thomas McDonald looked like before going in for routine and minor liposuction surgery. He had suffered from a condition known as gynecomastia as a child, and this is all in the record. He had already had one surgery when he was a teenager. However, obviously you're not done growing at age 13, 14. And as he became an adult, he was somewhat self-conscious about his chest. Dr. Saini, for $5,000, said she could do whatever he wanted. He paid in cash. This is the result. Full thickness burns on both sides of his chest. This is the starting point. I want to go all the way through these. As you can see, they're on both sides. And the record is clear that my client had to undergo multiple procedures and surgeries just to attempt to minimize the pain and disfigurement. These are well outside of any surgical field of cutting. And if you look at Dr. Saini's deposition, she tries to run from that fact. This is what Dr. Malcolm Marks, who at the time was the chief of plastic surgery at Wake Forest Baptist Hospital, he was the treating physician to treat these burns. He testified he had never seen nor heard of any type of burning like this for liposuction. He'd never read about it, never studied it, never experienced it. Dr. Detlef Erdman, the chief of plastic surgery at the time at Duke University, said he had never seen nor heard nor read in any medical literature about any type of burns like this, or any burns at all, quite frankly. Moreover, Dr. Levinson, who is the defendant appellee's expert, who's Dr. Erdman's colleague, he testified that but for Dr. Saini saying that there was no burning or fire or no heat source used, he would also believe these were burns. So he is simply taking Dr. Saini's word when she says that she didn't burn them. Well, that goes to the weight of the evidence, not to the admissibility or whether we've gotten over the hurdle. When the defendant appellee's own expert is saying that he agrees with the plaintiff's expert, but for the defendant appellee's denials, we have overcome the hurdle beyond res ipsa and past summary judgment and into a jury trial. And Dr. Erdman, when he diagnosed these as full thickness burns, went to look for heat sources. And you will see in the document that I'm showing you now that a Bovie Forest Valley lab was used. If you go underneath it, you can see that it was actually hooked up to him. Can everyone still hear me? I apologize.
I can still hear you.
All right, just wanted to make sure. But if you look
Could
at—
you go back to that last document for me real quick? Where are you showing that it was actually attached to him? Because I think that's a point of dispute. Can you clarify that for me?
Do you see, if you go under, do you see the column labeled equipment type?
Yes.
You go under, you see grounding pad, and then you keep going. It says location. Do you see where it says location?
Yes, right side. Okay. And which
Yes.
record page is that we're looking at here?
That is, it's a Rule 9D2. It's a Rule 9D2 exhibit, and we looked at it through the portal, the data portal. It is the second Rule 9D2 exhibit if you go through the portal that you can view these, and it is page 48 of the PDF.
Thank you very much.
Oh, you're welcome, Your Honor. And then the final document that I will show you, if you look here, it says a blank liposuction was used. And Dr. Erdman and Dr. Malcolm Marks, both chiefs of plastic surgery at major research university hospitals, have theorized that a vaser could have also caused these burns. Now, Dr. Saini testified that she didn't use a vaser. I believe some nurses testified that the hospital didn't even have a vaser. That goes to weight, not whether or not the evidence can come in. It goes to the jury weighing those facts. So just like in the Humphreys case, Dr. Erdman can't say for certainty because he wasn't in the room. And he is a very precise German doctor. And he says, I cannot say for certainty because I was not in the room. But these are burns. Burns have to be caused by a heat source. There were 2 heat sources. And the only way those heat sources could have caused those burns was by a breach of the standard of care. And then he lists out 4 ways that the breaches could have occurred. And that's what gets us over the hump. We've got the basically the injury the mechanism of injury, and then the breaches of the standard of care that led to the injuries.
Did Dr. Urban or Dr. Marks or anybody else in this case reject any theory that the scars could have been caused by post-op care and what was described having happened between the surgery and his return visit to Dr. Saini?
Dr. Urban, I would have to go back through and find that, Your Honor, but Dr. Urban and Dr. Marks, from my recollection, testified both that they do not see how that would be possible, that they do not understand how full thickness burns, and therefore that is not what occurred. Now, Dr. Levinson, the defendant appellee's expert, testified that because he believes Dr. Saini and the other individuals in the room, that it must have been something else. Well, obviously, Dr. Erdman and Dr. Marks don't believe Dr. Saini. They believe she burned my client.
What importance should we give to the fact that Dr. Erdman, at the time of his deposition, had not yet reviewed the depositions or statements from the other folks in the operating room, and he indicated that that would be of importance to him. I'm looking at his deposition, was at page 186, asking about what the others present would say and how that would impact his, basically his diagnosis or his ideas of what happened in the room. You know, since he wasn't looking at all of the available depositions, all the available records, all the available statements, what impact should that have for our consideration, since he says he doesn't have everything he'd want to look at to make a full determination?
With all due respect, Your Honor, I believe the impact of that would be appropriate for a jury, and the scope of the evidence from the nurses and the other surge techs that were in the room, it's lengthy. But if you really dig into it, and I hate to say it's hundreds of pages, the nurses testified that the heat source was in the room, the bovie, that the heat source was attached to my client, and that I believe several of the nurses testified that they had seen Dr. Saini personally use the bovie to go beyond simply cauterizing around the incision sites, that they had seen her use the bovie to excise, which obviously means to cut away, fatty tissue in gynecomastia surgeries. So I believe the weight of that would be more appropriate for a jury, and I truly believe that in this case, Dr. Erdman's opinion would not have changed, because he said repeatedly, these are burns. There is no question in my mind that these are burns.
So bringing your attention to, I think it's page 131 of his deposition, but also 130. That I think sort of bears you out, but it sort of sums up the case, I think, where, and there's some objections in there, so we won't deal with that, but basically Dr. Erdman testifies, I believe these are burns, and I don't know what caused the burn. And that, I think, kind of sums up the issue, is how do we explain to us how we kind of get around that kind of testimony? The same is true on page 130 of his deposition.
I'll be happy to, Your Honor. He's saying he doesn't know because he wasn't in there. However, he says burns have to be caused by a heat source. And then he identifies two heat sources, one of which everyone admits was there. The other is a disputed issue of fact. So yes, he does say, I don't know how what caused these burns. However, what he's doing is deductive reasoning. It's the differential diagnosis, the differential etiology. What do we have here? Burns. Well, there's nothing in the medical records about a burn or a fire occurring. Well, what causes burns? Heat sources cause burns. Let me look for heat sources. Okay, I found one clearly in the record, and then there's another type of liposuction that also could have caused this, and I've got a gap in the record. Okay, well now I've identified burns, I've identified the mechanism of injury, which is 2 potential heat sources. What could have gone wrong? Well, breaches of the standard of care. And he states explicitly that only the breach of the standard of care using those heat sources could have caused these burns. And that's just like the malpositioning case in Humphreys. And at this point, I see I have about 7 minutes left, so I would like respectfully to reserve the rest of my time.
Thank you, Mr. Porter. Ms. Becker? You're still on mute. There you go.
Great. Good afternoon, Judge Murphy, Judge Hampson, and Judge Young. May it please the court. My name is Gloria Becker of the Wake County Bar, and I have the honor and privilege of representing defendant appellee Dr. Sarah Saini, who is a board-certified plastic surgeon in Fayetteville, North Carolina, as well as her practice, Carolina Plastic Surgery of Fayetteville. Now, the sole issue presented to this court is whether Judge Gales properly entered summary judgment when the plaintiff appellant failed to establish through qualified expert testimony that Dr. Sarah Saini breached the standard of care and proximately caused the plaintiff's injuries. Now, we contend that summary judgment was appropriate because plaintiff's sole expert agreed that his opinions were purely speculative, and thus the plaintiff failed to establish 2 essential elements of his medical malpractice case with the requisite expert testimony. First, plaintiff's expert, Dr. Detlef Erdmann, solely based his opinion that Dr. Saini breached the standard of care on the injury itself. And by his own admission, he could not identify any specific facts or concrete evidence in the record that Dr. Saini breached the standard of care. Second, Dr. Erdmann agreed that his opinions related to the cause of the plaintiff's injury were purely speculative and that he does not know what caused what he believes to be burns. Now, while the plaintiff's position in this case has always been that he sustained a burn injury, it's important to note from the outset that the theories regarding standard of care and causation have changed over time. I highlight this because, as Mr. Porter indicated, a heat source is required to sustain burns. However, as the undisputed record in this case shows, there was absolutely no heat source activated or used during the plaintiff's surgery. Now, initially,
Ms. Becker, you know, we're saying it's undisputed, but how does that come into play in a summary judgment situation where the plaintiff is arguing, well, there's no other cause, so they're not being truthful? So doesn't that place it in dispute?
No, Your Honor. It's only placed in dispute if there's an issue of fact in the record. It's undisputed by all of the evidence, the deposition testimony, not only of Dr. Saini, but every single healthcare provider who was in the operating room, all the circulating nurses, as well as the medical record, that there was no heat source activated during the procedure.
So if all of the persons in the room get together and tell the same story and say what they want to say on the medical records, we don't have a video, we don't have any recording of the actual surgery, then a defendant doctor would always be entitled to summary judgment? If they say, oh, well, we didn't do that, and you don't have anything in a medical record saying we did do that, but an expert says, looks like you did that. So tell me why that's not what's going on here.
Sure, absolutely, Your Honor. So in every medical malpractice case, we have the medical records and we have testimony. Now, experts are entitled to infer things, but they have to make their inferences from specific facts in the record. And here, it is undisputed that a VASER was not used. A VASER was not even available at the hospital, and the plaintiff has not set forth any evidence contrary to that fact. Their reliance on this blank space does not create any inference of a genuine issue of material fact. When you look at the record as a whole, it conclusively established that Dr. Saini used a standard liposuction technique, which uses a tumescent fluid And then, by the record, she used an aspirator tube to suction out the fat. Dr. Erdman, their own expert, conceded that that gap or blank space, that he could only speculate that it meant vaser. He also speculated that it could just be a dictation blank, which he conceded that a dictation blank is not a breach of the standard of care. Erdman acknowledged, as was pointed out, that he hadn't even read any of the depositions of the other nurses, nor the complete deposition of Dr. Saini, where she unequivocally testified that she used an aspirator tube to perform the liposuction. He also confirmed that he did not read the nurses, who all testified that there's not even a vaser available at the hospital to be used, and that Dr. Saini used an aspirator tube model during this procedure. Now, what's important is that Dr. Erdman agreed that Dr. Saini, that the type of liposuction that Dr. Saini performed and documented in her operative note met the standard of care. And that she, based upon her note, that she performed a standard liposuction with no heat source. And that's on page 98 of Dr. Erdman's deposition. Now, plaintiffs should not be able just to make up or insert a word into the record that is completely unsupported by any of the evidence. That goes to the heart as to why opinions that are speculative are not reliable. Dr. Erdman ultimately agreed that he was eliminating this theory that the vaser could have caused, the vaser liposuction could have caused this injury. He eliminated that theory after he was presented with all the evidence, and that's on page 181 of his deposition. So it really goes to the heart, Your Honor.
Well, saying that that's eliminated, I think is kind of an interesting characterization, I would say. You know, he says, basically, yeah, if you take it that she didn't use a vaser, then that would eliminate a vaser. Or if there actually wasn't a vaser, that would eliminate the vaser. But he's not taking her word for gospel. He's questioning her word. He's questioning the testimony of others. So I guess, Tracy, you keep referring to a record, a medical record, but all those records are created by the defendant here. So a defendant in this situation has the unique capability to manipulate what that record is going to say. So how would a party ever fight against a case against a party that has the opportunity to create the record?
Well, Your Honor, the record that documents that an aspirator tube was used in this case was not created by Dr. Saini. That was created by the circulating nurse, Amy Lovingood. And that's the same record that Mr. Porter showed you. It's Cape Fear Valley Medical Record number 21. I believe he referenced it was page 48 of the PDF of the Rule 9D documentary evidence. So, Your Honor, if you're speaking directly to the credibility of the evidence, there's no inference that can be made that this is not a situation where we don't have clear, concrete evidence as to the type of liposuction that was utilized. It's documented in the records. It's documented by the testimony of Dr. Saini. And we have undisputed evidence by the nurses who are not defendants in this case, who say a vaser is not even available at the hospital.
So sorry, Ms. Becker, would you agree that it's not uncommon to have cases where you have an expert witness for an injured plaintiff who testify? I understand what's in the medical records. I understand what the doctor and the nurses have testified to. However, based on my experience and training and to a reasonable degree of certainty, that's not what happened, and and potentially with a differential diagnosis. In my professional opinion, to a reasonable degree of certainty, it was 1, 2, or 3, but it just wasn't what Dr. Saini testified to. I mean, that's not an uncommon occurrence in medical malpractice cases.
Certainly, Your Honor. There's no question that a differential diagnosis is a proven scientific theory that our courts have adopted as a reliable basis to form opinions. However, this is not a differential diagnosis case. And the plaintiff's reliance to bootstrap that into an argument to somehow make his expert's testimony sufficiently reliable is just not warranted. Now, a differential diagnosis, Your Honor, looks at all the evidence in the record, okay? Experts can only formulate their opinions based upon the facts in the record. You have to look at specific facts in the record. And here, Dr. Erdman, by his own testimony, conceded numerous times that there are no facts in the record that he can point to of anything that Dr. Saini did or did not do that amounted to a breach of the standard of care. What a differential diagnosis is, Your Honor, is when all of the potential causes are considered by the expert and they exclude everything until they have only one thing that's left.
Excuse me, could I ask you a question since you're at that point? Can you tell me what causes of injuries were eliminated to get to the expert's testimony?
So, Your Honor, we believe that it's exactly our point. Dr. Erdman's testimony is not sufficiently reliable because he has no idea by his own testimony what caused what he believes to be burns. He in and of himself, by his own testimony, eliminated that there was a fire. He also testified that he eliminated that a bovie could have caused this type of burn. He finally testified that since there was no vaser, that he eliminated that theory. And so he basically went through, all of the potential causes. And in fact, Your Honor, when I did ask him in the deposition, well, can you exclude that this was a due to post surgical care? He said, I can't exclude that. He couldn't exclude that it was just extensive hypertrophic scarring. He would say, I haven't ever seen that before, but it could happen. He also couldn't exclude the fact that it was from some type of dermatitis or allergic reaction. So this is not a differential diagnosis. And if you look at the cases actually that the plaintiff has cited, I mean, they support that this is not a differential diagnosis case. That the Fourth Circuit case made it clear that a differential diagnosis is only reliable when the expert eliminates all the likely causes until the most probable is isolated. Here, Dr. Erdman eliminated all of his own speculative causes, and therefore he doesn't even have a differential diagnosis. And in the State versus Maccabee case, the child abuse case, the court said, yes, a qualified expert can draw these inferences, but they can only draw them from specific facts in the record. They just can't make them up out of thin air. And that's exactly what the plaintiffs are doing in this case. They are making up facts that aren't in the record. And that's what goes to the heart of the reliability prong of Rule 702. So this is a case where we have 100% speculative evidence from their expert across the board.
How do you address the medical record that this reporter showed us from I guess it was page 48 of the 90 supplement? It appeared to show there was a connection located on the right thigh.
On the bovie. Yes, Your Honor. Thank you. Absolutely. So the circulating nurse and the surgical technicians, all three of them who are in the room, they're not defendants in this case, testified that a bovie machine is put in every single operating room, and it's hooked up for all invasive procedures in case it's needed. We agree with that. They also testified that the bovie is listed in the chart because it was present and available for use. It's hooked up and it's grounded to the right thigh. That just means it's hooked up. That does not mean that it was actually utilized. Dr. Erdman, plaintiff's own expert, testified that he agrees that an electrocautery device is routinely in the operating room, and just because it's in the operating room does not mean it is utilized. Dr. Erdman agreed on page 96 of his deposition that there's no indication in Dr. Saini's op note that she used the bovie. What's also important is that he further acknowledged that a bovie would be an unlikely source for the plaintiff's wounds because a bovie is used at the local incision site, and the plaintiff's scars in this case go beyond where Dr. Saini made her incisions. Erdman testified that the only way that a bovie could cause the injuries observed in this case would be if the bovie ignited a fire, and he concedes that there was no fire in this case. So that completely eliminates the bovie theory. I mean, there are many heat sources in an operating room, but they have to be activated and cause a fire to sustain these types of burns. There was no fire, and there was no heat source activated. So that eliminates his speculative theory that the bovie could have caused these burns. The laser vaser is completely eliminated by the record. This is not a credibility issue. This is not an issue where we have disputing facts in the record as to whether or not she used an aspirator or a vaser. It is undisputed that she used the aspirator too, which is not a heat source. Because of this, the plaintiff, as to the first essential element that they fail to prove is breach of standard of care. Dr. Erdman cannot identify any act or omission that constitutes negligence and base his opinion solely on the burn itself. And it's well settled that a plaintiff cannot rely upon a mere fact of injury to establish medical negligence. If the expert bases his opinion, as Dr. Erdman did, solely on the fact of the injury itself, which he did, their assignation of negligence on the defendant's parts constitutes mere speculation. This case is controlled by the Kenyon versus Garrett case, where the Court of Appeals in 2007 affirmed summary judgment in the defendant's favor based upon expert testimony that is virtually identical to the expert testimony in this case. The plaintiff experienced in Kenyon experienced a neuropathy, which she alleged was due to the wrongful placement of the retractors during the surgery. The injury was also identified to be a known risk of surgery, as it was here, and the plaintiff's expert testified that they assumed the retractors were wrongly placed solely on the fact that the plaintiff was able to walk before the surgery and had limited ability to walk after the surgery. They all agreed, as Dr. Erdman did, that they presumed negligence from the mere fact of injury alone. The experts also agreed, as Dr. Erdman did in this case, that if the retractors were repositioned during the procedure, as the defendants testified to, that the defendant's conduct would have complied with the standard of care. In Kenyon, the Court of Appeals affirmed summary judgment, noting that the experts gave no concrete reasons for their opinions that the defendants were negligent. And I'd like to read an excerpt from that case because it's directly on point to what we have before us in this matter. The court stated, essentially, all of the plaintiff's experts testified that their opinions were based upon the fact of the injury itself. Although they each, to varying degrees, put forth hypotheses as to the potential causes of the injury, none of them could point to any evidence of an act or omission other than the existence of the injury itself constituting negligence on the part of either defendant. There are several theories presented to show that defendants could have been negligent. However, all the plaintiff's expert witnesses based their opinions only on the fact of the injury itself. Their assignation of negligence on defendants' parts constituted mere speculation. And in this case, Dr. Erdman makes it clear numerous times throughout his deposition that the sole basis for his opinion that Dr. Saini breached the standard of care is the injury itself. He believes that because the injury was excessive and the scarring was excessive, she must have breached the standard of care. When we specifically asked him the question, and I'll quote, "Can you pinpoint to anything that Dr. Saini did or did not do that caused the third-degree burns or the excessive scarring?" He answered, "I cannot pinpoint this. It would be pure speculation. I have certain opinions that I can formulate, but I certainly cannot pinpoint it." He was also asked, if Dr. Saini performed the procedure as she described in her operative note, can you pinpoint to any areas where she breached the standard of care? And he said no. He was also asked, and based upon Dr. Saini's operative note, does it appear that Dr. Saini's technique and the procedure that she performed met the standard of care? And he answered, the report is consistent with the standard of care. And I think that raises the point that we're all aware of, but on summary judgment, this is just the first essential element of standard of care that we contend they can't prove. But once the moving party establishes this, that the opposing party can't, an essential element is non-existent, then once we've met that burden, then the opposing party may not rest upon the mere allegations or denials of his pleadings, but he is required to put forth specific evidence by way of affidavit or specific facts that establish otherwise, which this is not the case. It's not even a credibility dispute because there's no evidence in the record that Dr. Saini did anything to breach the standard of care. There's no evidence there. As to the second element, so we contend that summary judgment was properly granted because the required element of a breach of a standard of care from a medical expert is non-existent. But furthermore, Judge Gales properly granted summary judgment in Dr. Saini's favor because the plaintiff failed to prove the essential element of proximate cause. The plaintiff, sole expert, testified that there are two possible explanations for the burns, but in his own words, he agreed that both explanations are pure speculation. And I'll read his own words from his deposition. He said on page 93, a burn can only occur with a heat source, so I can only speculate two possibilities. Either it was an internal heat source, that means that the liposuction that was performed was not a conventional tumescent liposuction, but a different type of liposuction, such as a laser-assisted liposuction, or that an external heat source caused this, such as a fire in the operating room. In his deposition, if you go through the entire deposition, he, by his own words, not my words, but by his own words, he used the word speculation over 15 times to identify his causation opinions. Moreover, not only are these two theories speculative by Dr. Erdman's own admission, but they are completely disproved by the record, as we've already gone over. There was a bovie in the room, but the undisputed evidence that plaintiff has not set forth anything contrary is that the bovie was not used during the procedure. Second, there was no laser or vaser even available at the hospital to be used. So there was no heat source that was activated that could have caused these burns. Finally, Dr. Erdman testified on page 131, I believe these are burns and I don't know what caused the burns. So his testimony fails to meet all three prongs of Rule 702 and is therefore not sufficiently reliable. I mean, as to 702A1, his testimony is not based upon sufficient facts or data. In fact, it's not based on any facts or data in the record. It is not reliable. He bases it on nothing other than speculation by his own admission. And so this is not the case of Williams that Mr. Porter keeps citing to. In fact, it's a far cry from the unpublished opinion of Williams versus Humphreys. In that case, the court stressed that the expert testimony presented by the plaintiff that was missing in Kenyon and Campbell was present in the Williams case. In Williams, the plaintiff's experts were able to identify a specific cause of the injury, and that was the improper positioning. They did that by excluding all other causes. They said, look, the defendants weren't in the room the whole time, so their testimony, they don't know what happened between point A and point B. Moreover, in Williams, unlike we have in this case, one of the defendants documented in his record, in his note, that the likely cause of the plaintiff's injury was positioning. Finally, the experts in the Williams case identified that the most likely mechanism of the injury was compression of the lower arm. So this case is a far cry from the Williams versus Humphrey case. In contrast, Dr. Erdman acknowledged that he doesn't know what caused the plaintiff's burns, and he can only speculate as to what happened. And his own theories are rebutted by all the facts that are in the evidence. They even acknowledged that other potential causes exist, hypertrophic scars and keloids, such as trauma and infection. And I think it's important to point out that unlike in the Williams case, this is not a situation where the injury was discovered immediately after the procedure. Here, all three of the non-defendant nurses, Amy Lovingood, Hardin, and Miss Jordan, all testified that there were no burns during the procedure. Dr. Lovingood testified that she did a head-to-toe assessment after the procedure and that she found the skin to be intact, pink, had good capillary refill, and there was no evidence of any burns. She then applied the bandages all around the plaintiff's chest, and he was discharged that same day. So we have no evidence of any burns, undisputed, no evidence of any burns that occurred or were visible immediately after the surgery. He was discharged that same day, went home, and by his own testimony, he said that the tape that was used to secure the bandages a few days after he got home started to come loose. And he noticed at that time that he had, the bandages were wrapping around, and he noticed at that time that he had redness and what he calls blisters above and beyond the bandages. He then went to go see Dr. Saini on November 4th, and she documented in her note that he had redness and erythema above and beyond where the bandages were placed. And she assumed that it was an allergic reaction. So none of this testimony was even considered by the plaintiff's experts, but we've got a whole record that establishes that there was no burns during the procedure, and that the injury that he's claiming is undisputed arose by his own testimony a few days after the surgery in and of itself. So this is a far cry from the case in Williams and is directly on point to the Court of Appeals holdings in the Kenyon case, as well as the Campbell versus Duke University case. And before I conclude, I would just like to touch on your question, I believe, Judge Hampson, about the res ipsa theory. Now, while the plaintiff did allege it in his complaint, he does not refer to res ipsa loquitur in his brief, and thereby waives any argument that it applies pursuant to North Carolina Appellate Rules 10. However, this is not a res ipsa case. Res ipsa, as you know, typically does not apply in medical malpractice cases, and it does not apply here. The plaintiff's whole position is that direct proof is available of the burns. And so that is exactly what happened in the Kenyon and Campbell case, where the court actually did take a look at it and said, unfortunately, the plaintiff finds himself in this unfortunate position where the only proof that he can provide in support of the negligence is the fact of her injury. But her injury is not the sort that would allow an average juror to determine negligence in the absence of expert testimony. And that's exactly what we have here. Gynecomastia, revision surgery by liposuction, is a very complex medical procedure that requires expert testimony. The jury will not be able to sort out those type of facts without expert testimony. So res ipsa, this is not a case of res ipsa, not only for that reason, but also because, Dr. Saini wasn't the only one in the room. There were 3 other nurses in the room, and we've got evidence that, this happened after he left the hospital. So it's just not a res ipsa case, but I just wanted to clarify that, even though it wasn't really touched on. In conclusion, unless any of the other justices have a specific question, we contend that summary judgment was properly entered in Dr. Saini's favor because she proved not only 1, but 2 elements of the plaintiff's claims to be non-existent. Having met her burden, the opposing party may not rest upon mere allegations, but must set forth specific facts to prove his case. And having set forth no facts that are in dispute, and without the required medical expert testimony pursuant to Rule 702, the plaintiff appellant has failed to show any evidence why the motion should not have been granted. And therefore, we respectfully request that Judge Adams' entry of summary judgment in Dr. Saini's favor be affirmed. Thank you.
Thank you, Ms. Becker. Mr. Porter? You have just under
Yes.
30 minutes, sir.
Thank you. I would like to go to Judge Murphy's earlier question and point raised with my esteemed colleague, Ms. Becker, about facts in dispute and records being in the control of the defendants. First of all, she referred repeatedly to the nurses as non-defendant nurses. They were defendants along with Cape Fear Valley, and they were so shortly before they testified. Moreover, to get more specific to the question that Judge Murphy asked Ms. Becker, if the records say no Vaser was used, but the expert witness says to me, this clearly looks like a Vaser was used, that is a fact in dispute. It is no different than.
But let me stop you there. But doesn't that get to the issue is that we don't have testimony from Dr. Erdman that is, in my opinion, to a reasonable degree of certainty, to a reasonable degree, probability, it's probable. The only probable cause here is that the OR notes are incorrect. Dr. Saini's notes are incorrect and not reflective of what actually happened. It had to have been some electrocautery device, or in my opinion, it had to be this or this. The problem is, I think that he kind of hedges his opinions in terms of speculation, or it could, or well, if it's not that, it could be that, but that would be unusual or unlikely. And so I think that's what we're struggling with is how Dr. Erdman kind of poses these sort of differential opinions and causation. I think it's clear that I think it happens quite regularly that an expert can say, I understand what the surgeon said, I understand what's in the medical notes, but in my opinion, that's just not what happened. And I think that's the
Your Honor, Your Honor, if you look at his testimony, he says that the report shows that no breach of the standard of care, but the injuries do show there was a breach of the standard of care. And it goes back to Judge Murphy's point that if everybody just goes silent about something horrific occurring, then sorry, plaintiff, they all went silent on you. You're locked out of court. And if that is the ruling today, I believe it is going to have ramifications well beyond medical malpractice cases, because that same opinion can then be utilized, just like in a child abuse case, where I do think this is very similar to that. Well, this kid's burned. Well, none of us were there. Well, defendant, I guess you walk free, because no child abuse doctor, no pediatrician that specializes in child abuse can say with a reasonable degree of certainty that these are even burns. And I think what's important to remember in this case is that all inference of fact are taken in the plaintiff appellant's favor. Therefore, if you look within the testimony of Dr. Malcolm Marks, the chief of plastic surgery at Wake Forest, and Dr. Erdman, the chief of plastic surgery at Duke University, they both testified these are burns. Ms. Becker just said there's no evidence of burns. At the underlying hearing, she had to admit that for summary judgment, these are burns. For today, these are burns. And then Dr. Erdman, he reviewed all of the medical records to include the injuries themselves, which are photographs. So Ms. Becker keeps arguing that there's nothing in the record. There are the multiple pictures of burns. There are the extensive records from Dr. Malcolm Marks that say these are burns caused by a Vaser liposuction. Dr. Erdman testified that he reviewed those as well. So for today's purposes, the facts that can be inferred in our favor and that must be inferred in our favor are that the injuries are consistent with a Vaser being used, despite what the defendant appellee states, and that there was a second heat source in the room, a Bovie Valley Force cautery tool. And if you go through Dr. Erdman's testimony, and it is lengthy, Ms. Becker repeatedly, when she was deposing him, wanted him to say magic words. She repeatedly asked him leading questions about speculation. That is form over substance. It's a magic word meant to basically confuse the actual substance of an eminently qualified expert witness who was relying on the medical records of another eminently qualified plastic surgeon who repaired these scars, and that's Dr. Malcolm Marks. And
Let me ask a question real quick, kind of just deal with some substance and see. The allegation is the breach of the standard of care is that he was burned based on the doctor's use of whatever tool it was, whatever the heat source was, he was burned by it. Not the choice to use the heat source, correct?
Correct.
So would that be any different than if, you know, a heart surgeon that may cut an artery negligently, does it matter that he used a scalpel or he grabbed an axe? I mean, the difference, it doesn't really matter the tool if the breach of the standard of care is the negligent use of that instrument resulting in the burn, resulting in the scarring, correct? Or am I'm misidentifying what you're actually complaining about?
I believe you're correct, but I think the to that point, so yes, you're correct, but to that point, all three experts, so that means even the defendant appellee's expert, testified that they had never seen, heard, read about this in a liposuction surgery. And Dr. Erdman testified repeatedly that using those tools, to get to your point, Judge Murphy, whether it be an axe or a scalpel, the only way to cause the injuries and the burns sustained by my client was through using those tools inconsistent with the standard of care and breaching the standard of care. My client was burned. Those are the facts. The only way he could have been burned was by a breach of the standard of care. And we ask that this matter be remanded for a jury trial. Thank you.
Thank you. Any questions, Judge Hampson, Judge Young? Want to thank both of you for your arguments today. We will consider this case submitted, and thank everybody for being here today. Mr. Wood and Mr. Horn, you can go ahead and close us out.
Thank you. It was a pleasure.
This session of the North Carolina Court of Appeals is now adjourned.
Barbara.
I think you did good. Let's see.
How many likes did we get?